And I believe this is Mr. Jones.
Mr. Zachary Jones? Alrighty. Here we are. All right, now calling the matter of State of Georgia versus Zachary Jones. Charged in warrant numbers 2025 WA 74788, dangerous drugs. 2025 WA 74789, seatbelt violation. And 2025 WA 74790, theft by receiving stolen property. 2025 WA 74791, possession of a firearm by a first offender representing the state is ADA Thomas, representing the defendant is Attorney Rogers. Your witness, ADA Thomas.
Officer Williams, can you please raise your right hand? Do you solemnly swear and affirm that the evidence you should give to the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
And put your hand down, state your name for the record.
My name is Officer L. Williams.
How are you employed?
I'm employed with Clayton County Police Department.
And were you so employed on or about April the 5th of 2025?
Yes, ma'am, I was.
And did you have occasion to investigate an incident that occurred at Godby Road at West Fayetteville Road?
Yes, ma'am.
And is that within the confines of Clayton County?
Yes, ma'am, it is.
And during your investigation, did you come into contact with a Zachary Jones?
Yes, ma'am.
What brought you into contact with Mr. Jones?
Well, I was patrolling the area, Sector 2. I decided to drive towards the Godby Road area, and I seen the young man at the intersection. It was a four-way intersection. I seen the young man operating the vehicle. The young man would actually be the Cameron driver. He was operating the vehicle with no seatbelt on.
Okay.
So that's what made me conduct the traffic pull-over.
So where was Mr. Jones at the time?
Mr. Jones was the front passenger.
Okay. So what happened subsequent to the traffic stop for no seatbelt?
So once I conducted the traffic stop, I activated my license sirens in my patrol vehicle. The Cameron driver, the operator, he pulled into the nearby gas station, jumped out of his car, and he attempted to put gas in his car as if he didn't hear my sirens or see my lights. I exited my vehicle. I approached the operator and I advised him that I was conducting a traffic stop. I then told him the reason for the traffic stop. He advised that he was, that the seatbelt was actually up under his arm, and that's why I couldn't see it. The young man wasn't wearing a shirt, so a black
Which young man?
The operator, Cameron driver.
Okay.
He wasn't wearing a shirt, so it'd be very clear that he wasn't wearing a seatbelt. While speaking to that young man, the defendant that we're speaking on, what is his name? I don't want to get his name.
Mr. Jones?
Yeah, Mr. Jones. Yes, ma'am, Mr. Jones. He jumped out of the vehicle from the passenger side and approached. He advised that he wasn't.
Okay, officer, stop. You're breaking up a little bit. The last part I heard was he jumped out the vehicle. What happened after that?
Mr. Jones jumped out of the vehicle from the passenger side and approached me and Mr. Driver speaking. Mr. Jones stated that he wasn't wearing a seatbelt and maybe I seen him instead.
What did you say then?
I advised him that we'll get to that, but I was speaking to Mr. Cameron at the time.
And what happened next?
I called for additional units due to it being 3 subjects inside the vehicle, and I was a solo officer at that time.
Okay. Did other units respond?
Yes, ma'am.
And in the meantime, where was Mr. Jones? What was he doing?
Mr. Jones went back to the vehicle and sat in the front passenger side.
Okay. And did you come into contact additionally with Mr. Jones?
Later during the scene, once additional officers arrived to the scene, one of the officers seen residue on the pants pocket of Mr. Jones.
When you talking about residue of what?
It was a green leafy substance suspected to be marijuana.
Okay. And by this time, Mr. Jones is back in the car?
Yes, ma'am. Now,
where was the driver?
The driver was still outside of the car with me. I I was checking his driver privileges using GCIC, and it came back suspended. So he was detained, placed in handcuffs and detained.
What happened with Mr. Jones?
Once the residue was seen, Mr. Jones and the rear passenger was detained, exiting the vehicle at the exact same time, placed in handcuffs and detained while a search was being conducted of the vehicle.
And what happened as a result of that search?
During the search, 3 items was located. A pink substance was located. We couldn't determine what that was, so it was sent to the GBI to be identified. It was field tested, but the field test was inconclusive.
Now, was anything else found in the car other than whatever this mystery substance was?
Yes, ma'am. It was a firearm found inside the vehicle, and it was a whippet, it was what do they call it? Basically, a whippet is a inhalant. They use it to get like a high that's relative to alcohol.
Okay. What about, were any weapons found in the car?
Yes, ma'am. It was a firearm found, a pistol firearm.
Where was that found?
It was found in the front passenger seat, front side.
Is that where Mr. Jones was?
Yes, ma'am.
Okay. Now, Mr. Jones had previously admitted that he didn't have on a seatbelt, correct?
Yes, ma'am.
The firearm itself, what happened? What was going on with it? Was any investigation done regarding it?
Yes, ma'am. The serial number of the weapon was checked, was validated using GCIC, and it came back stolen.
So, do you recall where it was stolen from?
It was reported stolen from Douglasville, if I'm not mistaken.
Okay. And did Mr. Jones say anything? I know he acknowledged not wearing a seatbelt. Did he say anything about the weapon?
Nope. No, ma'am. He denied that the weapon was his, but he also stated that no one would claim a weapon. But he did deny that the weapon was not his. He said that he's fighting a case for having a weapon, so why would he have a weapon?
Okay. Now, but it was found at his seat, in his seat, or on the side. Where exactly was it?
It was found under his seat, but to the front of his seat.
So not where the back seat passenger could have put it?
Yes, ma'am. Not where the back seat passenger could have put it.
And I believe you made an additional charge of possession of firearm by someone with a previous history. Is that correct?
Yes, ma'am.
And what was the basis of that?
After the young man stated that he had a charge that he was fighting due to being in possession of a weapon during the crime, I did a criminal background check on him, and he was charged with that charge and was placed on probation.
So he had actually been convicted of a weapons charge previous to this?
Yes, ma'am.
Do you recall what jurisdiction he was convicted out of?
I don't want to quote the wrong jurisdiction, but I believe it was the same as the stolen weapon, Douglasville.
Okay. Douglas County?
Yes, ma'am.
Okay. Now, were you equipped with body cam or anything like that?
Yes, ma'am.
And was it active and working during your interactions with Mr. Jones?
Yes, ma'am.
Do you know if it captured your interactions with Mr. Jones?
Yes, ma'am.
And I believe you mentioned that you had to wait for other officers to respond to the scene. Is that correct?
Yes, ma'am.
Were they equipped with body cam?
Yes, ma'am.
And was that operational that you know of?
Yes, ma'am.
And where is all this body cam now?
It's stored and saved through the county.
So is it attached to your report, or it's just on the PD server?
Just on the PD server.
Yeah, I believe that's all I have at the time. Reserve right to redirect.
All right, Cross?
Oh,
Oh, Attorney Rogers, we can't understand you.
How about now? Is that any better?
That's better.
Okay. All right. I was just saying, also, just a few questions. I think you kind of got at it, but I just want to make sure I have you clearly. Mr. Jones is not the driver, right?
No, sir.
The driver is driver, right?
Yes, sir.
Okay. As far as you know, Mr. Jones, he's not the owner of the vehicle, correct?
No, sir.
And if I understood, I think you said it was 3 people total in the vehicle, or maybe I got that impression for something, but 3 total, right?
Yes, sir.
As it relates to the gun, Mr. Jones, he's never seen an actual possession as far as like handling it or anything like that, correct?
No, sir. I didn't. No, sir.
And I'm kind of basing it on the fact that it seemed, if I understood you correctly, the gun was only uncovered after a search of the vehicle, like it wasn't laying out in plain sight when you first started dealing with them or anything.
Yes, sir. It was recovered during the search of the vehicle.
No further questions.
All right, any redirect?
No, Your Honor.
Closing arguments?
I'll reserve.
Go ahead, Attorney Roger.
Thank you. Judge, I guess a couple of things I'll say about it. And hang on I just want to make sure I got all the charges. I think my first argument is going to be as it relates to the alleged dangerous drugs charge. No substance was identified that I heard. There was the terms whippet and inhalant were used, but those aren't the names of any particular substance. So I would say that there's been no testimony that would support a finding if the alleged substance is not identified or even alleged in any way, then it's insufficiently specific to support the charge. There are, substances that are covered, but you have to identify one of them, and the names whipping and inhalant are not covered charges. So I'd ask for a dismissal as it relates to the dangerous drugs charge. With regard to the violation of the seatbelt charge, I'll submit on that one. Sounds like that, I guess Mr. Jones is alleged to have conceded that. I will now turn to the theft by receiving and the possession of firearm by a felon, or not even sure exactly what's being alleged because I don't know that it was established that it was a felony charge. So that's one of my basis for arguing that it's not, hadn't been established that he's either a convicted felon or a first offender probation. But putting that to the side for the moment, the bigger issue, and I think it covers both of those charges, the firearm and the theft by receiving charge, is that there's been no basis for possession alleged. As it stands right now, my understanding is that Mr. Jones is not the driver, not the owner, just a passenger in the vehicle. The only thing that's been alleged to connect him to it is that I guess it's supposed to be near him in some way. That seemed to be what they were trying to get at, is that he's the front seat passenger and the gun is under the front seat. So tag, he's it. That's not the law. The law is that there's no presumption of possession because when a person is not the owner or controlling the car, when they're just a mere passenger, there's no presumption of possession. And I'm right now reading from Mitchell v. State. This is a Georgia Supreme Court case, 268-592. In this case, they were talking about cocaine, but it's relevant for the discussion of contraband. And I got a couple of other cases coming. But the fact that the cocaine in that case was found on the passenger side of the car is of no consequence. That is a direct quote from Mitchell v. State. So a finding of constructive possession of contraband cannot rest upon mere spatial proximity to the contraband, especially where, as here, the contraband is hidden. As Officer testified to, he didn't see it. It's not laying out in plain sight, the firearm. So, in this case, the contraband sounds to be hidden. But even if it wasn't, just being near it is not enough to put you in possession of it or even to support, that allegation. There's another appellate case, Hunt v. State, 358, Georgia App 897. This one, court talks about how a probationer's mere presence in the area where a prohibited item, and again, I'm reading directly, where a prohibited item is found will not justify a probation revocation based on possession of the prohibited item, even under the more relaxed preponderance of the evidence standard. In other words, there must be something more than mere spatial proximity linking a probationer to the prohibited item. The court goes on to say that nothing other than spatial proximity linked Hunt to the gun concealed under the front seat of Green's car. As a passenger in the vehicle, his presence alone cannot establish possession. And I can go on, Judge. I got another case lined up. Same idea. It's Wofford v. State. Again, just to get to the point of it, the arresting officers stated they did not see Wofford bend over or appear to put anything under the seat. No other circumstantial evidence linking him to the gun. Moreover, because Wofford was only a passenger in a car that he did not own or control, there is no presumption that he possessed the gun. Says under these circumstances, and Judge, I'll ask that the officer, number one, I guess, be put in the weight room and people try to, make comments during closing. Is what it seems to be happening. But additionally, as I was saying with Wofford, says that Wofford was only a passenger in the car that he did not own or control. There's no presumption he possessed a gun. Under these circumstances, Wofford's mere spatial proximity to the gun is insufficient to support a finding beyond a reasonable doubt that he knowingly possessed the gun. So this is just not enough evidence. And the reason I say that it covers both of the charges is because if he's not in possession of this item, obviously he can't be in possession for purposes of being a felon or whatever is alleged. And he's also not in possession for purposes of theft by receiving stolen property. You got to possess the property in the first place to be able to be charged with theft by receiving about the property. So he's not even in possession of the property. But just to address the theft by receiving part of it, we got Sharp v. State, Georgia Supreme Court case, 310 Georgia 254, 2020 case. Court, this is, if I'm not mistaken, I believe that the factual circumstances are murder, but he's also charged with theft by receiving stolen property. Although the court found a basis for the crimes of violence, the Supreme Court says that although the state produced evidence that the gun had been stolen approximately 10 months prior, and that Sharp was in possession of it shortly after the shooting, the state offered no other evidence relevant to this count. Specifically, no evidence from which a jury could infer that Sharp knew or should have known that the gun was stolen, which is required for the charge. So in that case, they reversed the conviction for theft by receiving stolen property, and they cited Doughty v. State, which is another Georgia Supreme Court case, and this is the parenthetical in Sharp. It says, because evidence shed no light on defendant's knowledge of the handgun's provenance, evidence was insufficient to enable a rational jury to find him guilty of theft by receiving stolen property. There was no circumstances, listed that would say that Mr. Jones either knew or should have known that this firearm was stolen. None at all. So for those reasons, Judge, I would ask that all of the charges except for the seatbelt be dismissed for lack of probable cause. Thank you.
Righty, ADA Thomas.
Yeah, one thing that the officer said, actually to address the possession of dangerous drugs. The officer indicated what initially brought their attention to this gentleman who was the passenger was the fact that he had that residue on his lap, which I believe they indicated as marijuana. He later testified that they found something called, I guess the street name of it is whippets, which is actually nitrous oxide. Excuse me, nitrous oxide.
That wasn't testified to, and now she's trying
He had to explain what whippets
was. Hold on. Let him finish his objection, ADA Thomas. Go ahead.
That wasn't testified to. The officer didn't say that. She's making statements about what things are called, but that wasn't testified to, Judge. So
I didn't hear that, ADA Thomas. I didn't hear him testify.
Explain what whippets was. Now, he did not use the word nitrous
oxide. Judge, I object.
Right.
She's not allowed to testify. She's not a witness.
Yeah, I'm responding to the court. At least I'm trying.
Go ahead and respond.
Thank you. The officer testified that it was whippets. He did not specifically use the term nitrous oxide.
Okay, wait, you can't use that term, ADA Thomas.
And I will withdraw the term. But he did say that it was an intoxicating substance similar to alcohol, if memory serves. He also indicated that where the weapon was found, I asked him specifically, was it towards the back or towards the front? He says, no, it's towards the front. Towards the front passenger is where the weapon was located, accessible to the front passenger, not the rear passenger. He was able to verify that this weapon was in fact stolen out of Douglas County, because when we got to the part about this defendant being a convicted felon, he initially stated, yeah, I don't want to say this wrong, but I think it's from the same jurisdiction, Douglas County. So he was able to establish that this young man is a convicted felon out of Douglas County, and that this weapon was stolen out of Douglas County, and that this weapon was in fact within his wingspan or reach, right under the seat where he was sitting. State would contend at this point the sufficient probable cause has been established to transfer the case in its entirety to the Superior Court.
I just have a question. And ADA Thomas, you can direct it to the officer if you like. So the gun was located in the front seat. Was it underneath the seat, or was it just in the front seat area?
Now, Your Honor, my recollection of what he said was that it was in the front, under the seat, but in the front, that like right under the front edge of the seat. Now, I can direct the question to the officer to make sure I'm not misquoting him. Officer,
Yes,
is the court wishes.
If we get into just, volunteer our recollections of the evidence, I would also like to volunteer my recollection of the evidence.
Your Honor, I believe I responded to the court's question, and that the court also asked it if I needed to.
And I'll let you respond, Attorney Rogers. Go ahead. Officer.
Okay, yeah, I wait for who you want to go next.
ADA Thomas, you were asking the officer a question?
Yes, ma'am, and in response to the court's question.
Yes.
And I asked him if my recollection was incorrect. Where did you find the weapon specifically?
The weapon was on the floor up on the seat towards the front of the front seat, the front passenger seat.
So it wasn't laying on the seat?
No, it wasn't laying on the seat. It was right up on the seat.
All right, Attorney Rogers, you wanted to add something?
I mean, I think I just would also point out that what was also testified to is that it was not in plain sight, and that it was uncovered during the search.
Right, that's what I was getting at. That's where I was going with that. All righty. And another question, there were how many people in the car?
Yeah, my understanding is it was three, one backseat passenger and the driver and the passenger on the front, because the officer indicated that he had to wait for backup because it was 3 and 1, the 3 being the defendants. Well, the persons in the car, I should say.
Hold on one second. All righty. So based upon the evidence presented, I am going to bind over all the charges to the Superior Court of Clayton County. That's the order of the court.
Thank you, Your Honor. Officer, you excused.
Thank you.
We have any, I know it's Attorney Lewis, you have one?
I have several, Judge, but I believe the manner that I can end very quickly requires me to talk to my client for just a few minutes. And I think we're already at your time threshold, so I think that's going to be the fastest thing that can be done.
Okay. And so I'm going to put you in 2.
And to the
If you
jail,
would,
I need that young lady in front of that camera, Jade.
so if you would go
I'm
ahead.
not,
We're done with Mr. Jones.